Knowing what your landlord can and cannot do can be confusing. This is even more true if you have a disability, as there are special laws that apply to you. We are here to help explain some of that and provide resources for help. My name is Tia Barak, and I am a student at Wayne State University Law School, located in Detroit. We are working with the Community Development Advocates of Detroit to help Detroiters understand their rights when it comes to accessibility and accommodations in housing. First, it is helpful to know that there are some laws that make it illegal to discriminate against people with disabilities. Some laws require a landlord make what are called reasonable accommodations for a tenant with a disability in certain situations. Sometimes, tenants and landlords don't really understand their legal rights and responsibilities. The purpose of this video is to help you understand some of these rights and responsibilities and where to go for more information to get help. The Federal Fair Housing Act, or FHA, is an important law that can be very useful to those who are facing a housing-related issue. One important thing that the FHA does is that it does not allow discrimination in housing if a person has a disability. To be able to understand whether you are protected under the FHA, you must really understand who this act was created for. The Federal Fair Housing Act describes disability as someone who has a physical or mental condition that limits the quality of life, or have a medical history that shows that they have had a physical or mental condition that affects the quality of life. Some examples of disabilities include, but are not limited to, visual issues, speech issues, hearing issues, cancer, autism, HIV or AIDS, and emotional illness. Now, just because it's not listed on the screen does not mean that it is not a protected disability. Searching for a home is stressful enough. Worrying about whether a landlord will refuse to rent to you because of a disability is not something you should have to worry about too. Here are some things that a landlord cannot do. First, a landlord cannot refuse to rent to you on the same grounds given to others or ask questions about your disability during the application process. A landlord cannot refuse to grant your request for a reasonable accommodation that would allow you to live in a unit and enjoy it fully. Now, it's important to know that you may request an accommodation while you're in the application process, but you also can request this after you've already moved into the unit. A landlord cannot refuse to allow you to make reasonable changes to your unit. And lastly, a landlord cannot treat you differently or threaten and harass you because of a disability. Now let's break this down further. If you are applying to rent a unit, the landlord cannot reject your application because of a disability. Landlords are also not allowed to ask certain types of questions about your disability. You may not be asked for certain kinds of general information about yourself that relates to your disability. For example, it is illegal for a landlord to ask you if you are capable of living alone. A landlord may ask questions related to disability under only two circumstances. If you're applying for housing designed or designated for people with a disability, it is legal to ask if you qualify for such a unit. Or if the housing is designated for people with a particular disability, it is legal to ask if you qualify for such a unit. If you're not applying for housing designed or designated for people with disabilities, a landlord may not ask you about your disability unless you request a reasonable accommodation, which will be discussed further along in this video. It is important to know about two situations where the landlord may not have to make a reasonable accommodation. Number one, if a landlord owns and lives in a home with 4 or fewer rental units, the landlord does not have to provide the requested reasonable accommodation. A rental unit can be a house, apartment, or room. And number two, For rental buildings without an elevator, only the first floor units need to be wheelchair accessible. If you have a disability and do not fit into one of those two exceptions, then you are allowed to request a reasonable accommodation. We've talked a bit about something called a reasonable accommodation. But what is it exactly? The FHA tells us that a reasonable accommodation is a change, exception, or adjustment that would help better the quality of life for a disabled person. Simply put, this means that a reasonable accommodation usually addresses a landlord's rules on a property that may not be working for a tenant with a recognized disability. Some examples of what a solution to a reasonable accommodation request can look like is something like an open floor plan, or a model with only a few steps so that a ramp can easily be installed. The ability to modify doors to accommodate certain limitations by disabilities, and ensuring the correct angles into restrooms so that they're more accessible for wheelchair users and those limited. Knowing how to request a reasonable accommodation is important, but it does not have to be hard. You can make the request by speaking to your landlord or by asking in writing. It's better to put the request in writing. By writing an email, letter, or text, you have proof. If you simply just ask your landlord while you're passing by in the hallway, there's no proof or way to show that this request happened. Your landlord could say they never heard it, or that you guys never even spoke. The landlord must reply to the request in a timely manner. You do not have to prove your disability if it is something that the landlord can see, like someone who's blind or in a wheelchair. But the landlord can ask for more information to make sure you have a disability that requires an accommodation. There are some documents that can be helpful to provide the landlord with. This could be Social Security benefits or disability benefits. It could be a letter from the doctor stating that you need this accommodation to help you in your daily life. You can do this by bringing a copy of your approval letter from Social Security or disability, or proof of a check that was issued by them. To make things easier, giving your landlord these documents with your request may help speed up the process. There are situations where a request for a reasonable accommodation can be denied. A request may be denied if it isn't considered reasonable. Sometimes, although a feature of a building may be inaccessible to some people with disabilities, it may be unreasonable for the landlord to be able to fix this issue. This could include something drastically being done to change the housing situation. For example, this could be setting up a ramp on all floors of an apartment building when setting up the ramp would require reconstruction of every floor. Or it changes how the space can be used by the landlord, or it's too expensive for the landlord and would create a burden. Many times, landlords are running their own businesses and are in charge of expenses. Some of these accommodations may be denied if it is not reasonable for the provider to be able to financially provide what is being asked of them. If your request for an accommodation is denied, there are places you can go to for help. You could go to an attorney, or you could go to an organization that specializes in these issues. If you believe that you have been the victim of housing discrimination, you can contact the Fair Housing Center. Their contact information is listed below. Housing is a human right. Accessible housing for those with disabilities is no different. We hope this video was helpful to understand how to recognize housing discrimination, know your rights and protections that you have when it comes to accessibility and accommodations for housing, and what you can expect in the process.